Now, Goldstein Buckley personal injury attorneys present Counsel's Corner.
I'm Christopher Smith, and this is Andrea Smith, and we are husband and wife and law partners with Goldstein Buckley personal injury attorneys. And today we're here to talk to you about comparative fault, which is a legal term that we use. And Andrea, could you explain to our viewers what comparative fault is?
Sure. So comparative fault, it arises in situations where an insurance company might be trying to argue that the injured party is to some extent responsible for their own injury. So they put a percentage on a fault on the plaintiff or the injured party in the lawsuit.
Could you give the viewers some examples of how that plays out and what sort of cases we see that in?
Sure. So it's most commonly something that we see in trip and fall and slip and fall cases where an insurance company will argue that the injured party is actually at fault for their injuries. So they could have been more careful where they were walking or things of that nature are the arguments that we typically see.
And have there been some recent changes in the law with respect to comparative fault?
There have been some very significant changes with respect to that area of law in the past couple of years. So most significantly, the law now is such that if a plaintiff or injured person is found 51% or more at fault by a jury, they don't get to recover for their damages.
So how has that impacted how insurance companies handle comparative fault cases, and why should someone hire an experienced attorney to deal with that?
So insurance companies, as you can imagine, have been trying to take advantage of that change in the law. And so that's why you really need an experienced personal injury attorney who is willing to litigate your case and potentially try it if necessary.
If you've been injured in an accident, call us for a free consultation at 239-500-HURT or go to justicestartsnow.com.